Well, good afternoon, everybody. My name's Elizabeth Kennedy and I'm the General Counsel at Peter MacCallum Cancer Institute, and I'm delighted to MC today's lunch live at the VCCC building. I'd like to first acknowledge the traditional owners of the land on which this event is taking place, the land of the Wurundjeri people of the Kulin Nation, and pay my respects to their elders and families, past, present and emerging. Those of you who are regulars at these lunchtime seminars will know very well the purpose of the Victorian Comprehensive Cancer Centre. But for those of you who may be attending off-site or for the first time, I need you to know that the VCCC is a powerful alliance of 10 successful Victorian organisations committed to cancer control. The role of the VCCC is to coordinate the collaboration between its member organisations, of which I'm very proud to announce that Peter Mac, of course, is one, and to develop a strategic program of work that integrates research, education and clinical care to maximise patient outcomes in a cost-effective manner. So welcome everyone, and those of you who are attending via video link to today's presentation. We have some very interesting speakers coming up in the program. I'll say something more about that at today's conclusion. But today it gives me great pleasure to introduce today's speaker to you all, Dr. Lachlan Wilson, who is a patent and trademark attorney, and as you can see from his slide, is currently the Acting Associate Director, Technology Transfer and Licensing for the University of Melbourne. He's highly experienced in patent management and in the protection and commercialisation of intellectual property. He has gleaned this experience at the Melbourne University, Trobe University, Walter and Eliza Hall Institute of Medical Research and Agriculture Victoria Services Pty Ltd, and has spent time as a patent attorney at Watermark Patent and Trademark Attorneys. Dr. Wilson is the author of scientific publications and is the inventor on several patent applications in protein discovery and vaccine development. Today, Lachlan will be demystifying the complex world of intellectual property in clinical science research. Who owns IP? Can we be sued by a third party for carrying out research in breach of someone else's IP? How do you successfully publish about your discoveries and inventions without breaching intellectual property rights? And then how do you commercialise those all-important research results? Please help me in welcoming Lachlan to the podium today. Thank you, Lachlan.
Okay, thanks very much for the introduction and welcome everyone. Thanks for coming along. IP is simple, really, and I'll show you how. I'll give you a brief, really brief introduction to IP, and there's what I think is really important. There are three most important parts of intellectual property: copyright, patents, and the other one's a secret. Copyright is the expression of ideas. Copyright protects the final form of something like this complete Sherlock Holmes, or it might be some software that's written down. Patents are all about the idea itself. So copyright protects the expression of the idea. Patents are about the idea itself. But what makes a patent? Well, that's a secret. But when I say it's a secret, I don't mean I'm not going to tell you. I mean, it's a secret, right? So secrets are the key ingredient for a patent. And that's a really fundamental concept. Now, I've got your attention. Let me tell you what else I'm going to talk about today. A bit more detail about intellectual property after that introduction. Who owns your intellectual property? 6 types of things that can be patented. I'll get you to be the judge once you've had a brief introduction on how to do that. Then can you be sued for doing research? My 6 top tips for publishing and commercialisation. And then I'll finish up with some telling you about some research that we did in the law school before I came into this role on patent evergreening and how a patent monopoly can be extended. So intellectual property has 2 key families. The non-registered IP is quite easily created. You have an idea, develop a new technique, or take a photo, and it just comes into existence. Registered IP has a formal process where you make an application to the government. Within those 2 families, let's start with confidential information and know-how. What is it? That's all in your head. That's where it starts, with an idea. That's not just general information, but specific information. So not just how to catch a bus, but specific technical information and accumulated experience. It's very difficult to transfer to someone else, so it's very vulnerable. If someone leaves the team, then it can be lost. Now, if that know-how can be converted some way, written down, or coded in some way, then it can become a trade secret, which is confidential, valuable secret. And trade secrets fall into 3 categories, I suppose. Sorry, 2 categories: technical information and operational information. So that's technical information might be experimental results, so new data that's just been received, the formulas and the experiments, the techniques themselves when they're written down, technical information. Also, operational information like the strategy of the research group, the customer databases of a company, the competitor analysis, any sort of strategy that might be trade secret. Also in that area is new data that hasn't yet been patented. So it might not stay in that category for very long, but at that point you have a decision. There's a decision point when new knowledge is created. So if you think of that as the stem cells of the intellectual property world, that's where it all starts. And from that we have a decision we have to make, whether we keep it secret, whether we share it under a confidentiality agreement, whether we publish it, or whether we try to patent it. So we're moving it from a vulnerable type of intellectual property to something that has a little bit more protection about it. Then let's move into copyright. Copyright immediately exists when it's been fixed into its final form. So it falls into 4 categories: dramatic works, which are works that are designed to be performed, like plays. Musical works, that's the musical written text, written notation. Literary works, which is most of what we come across, which is books and articles, anything that's written down, even an email. And artistic works, which are anything from photos to TV broadcasts and films, anything like that. Now, you remember I said patents can protect the ideas behind an invention. They might protect various categories like compounds, new chemical entities, new pharmaceuticals, new derivatives of pharmaceuticals, new antibodies, anything like that. The processes that you can protect with a patent might be processes for making the active pharmaceutical ingredients, methods for developing a new test, for purifying a compound, anything like that can be protected with a patent on a process. Then methods can be patented, and they can be methods of medical treatment, methods of treating. So, for instance, an existing drug might be repurposed for a new condition. So, a method of treating obesity using a drug that was previously known to treat depression. That might be a patentable method. And then there are devices and formulations. So medical devices can be protected by a patent. Drug delivery formulations like transdermal patches and slow-release formulations, all of those things can be protected by patents. Then designs, there is a formal protection mechanism for protecting the new aesthetic or ornamental way that a commercial product looks, like the two-dimensional aspects like the patterns on a jumper, or three-dimensional aspects like a way a phone looks, a new phone. Domain names are a way of securing a URL, but they provide no protection against someone else from doing anything similar. Plant breeders' rights can give exclusive rights to new plant varieties like a tastier strawberry or a more vibrant red rose or something like that. And business names are required for anyone carrying out a business in Victoria or Australia, but they don't provide any protection on their own. So you can see all these things fit together and do a different thing. And then the last but not least, trademarks. So trademarks are more familiar to us all. But they are so much more than just logos. We all know the familiar logos that we get every day, but trademarks can be so much more. They can be sounds and smells and colours, even movements. Does everybody know the Toyota "Oh What a Feeling" jump? That's trademarked. Anybody want to come and demonstrate it for me? That's a trademark. Okay, so with an IP register like this, you can map out all the IP going into a project or even coming out of a project and see in one page what you can simply protect, deal with, collaborate and safely talk about with your intellectual property. And if you want to print that out, there's all the details. So, who owns your IP? Well, let me quote from a court case. At risk of making this boring, there was a court case, Victoria University versus Wilson. That wasn't me. I just got to say that, right? But it was a university employee at Vic Uni. And the judge said at the end of that in Australian IP law, that it's an implied term of employment that any invention or discovery made in the course of employment during employment time and work hours using the materials of the employer, then the invention is the property of the employer and not the employee. And that statement has been ratified by higher courts. That was the Victorian Supreme Court that said that. So that's the position under Australian law, that the employer owns the property of the employee. That applies whether you're in McDonald's making burgers or whether you're at the University of Melbourne making inventions. That was certainly the case for all the patents that I was on. I got a $10 coin that I still have. That was what I got, and my employer got the invention. Now, can I ask, who has a connection here with the University of Melbourne in some way? Employment, staff, students? Quick show of hands. Yeah, collaborate with someone over there. Thank you, Eric. Good. So in the University of Melbourne, I'll tell you about the University of Melbourne framework for how it operates and how that relates to intellectual property. The University of Melbourne has a statute in the Victorian State Parliament, the University of Melbourne Act, and under that is the University Statute. And I'll go straight to that relevant part there. So the University of Melbourne Statute, Section 13, says that the university owns intellectual property created by staff in the course of or incidental to employment with the university, except copyright in scholarly works. So that's quite clear. The university owns the intellectual property of the staff, and that reflects the law. And what about students and honorary appointees? So they fall into two categories. The university owns intellectual property created by students and honorees whilst they're engaged in a specified agreement, whilst they're engaged in an activity which is the subject of a specified agreement, or that intellectual property constitutes teaching materials. Otherwise, they don't. Otherwise, the university doesn't own it. So if you read that carefully, students and honorees might fall into two categories. The university might own the intellectual property when there's a specified agreement, and I'll talk about that on the next page. Otherwise, the university is not claiming ownership. So there might be someone else that's claiming ownership, or it might be belonging to the student. The specified agreement is any agreement or a deed between the university and some other party. So if there's an agreement, if there's a grant maybe, then there's a contract between the university and the NH and MRC or something like that, then that will form a specified agreement, and that specifies what the ownership of the intellectual property is. So in that scenario, the university will own the intellectual property, not the student. If there is an agreement where the student just has a stipend, a living allowance or something like that, that has nothing to do with intellectual property, then the student may well own their own intellectual property. And that will be the case in many organisations that we're dealing with here, that the organisation claims ownership of the intellectual property and it's not individually with the staff member. At the University of Melbourne, that's not all bad news. The university shares 40% of the net commercial revenue with the inventors. So recall I just told you I got $10 for my patent. Well, at the University of Melbourne, the creators can share in 40% of the royalties that come through, and we typically see about $1 million a year that comes through and ends up in the private pockets of individuals, creators that have patented inventions through the university. So I'm going to give you a quick introduction into 2 slides into patents, and then I'm going to get you to be the judge. Tell me if you agree with what the court said. So a patent is a monopoly. Ordinarily, monopolies are illegal, but patents are legal monopolies granted by the government in exchange for the disclosure of a secret. So there's a deal going on between an inventor and the government. The inventor gets exclusivity, they get that right to protect their intellectual turf, and the public, at the end of the patent, gets knowledge of the invention, and anyone can carry out what the invention was. So there's a deal going on there between the inventor and the government. What do you need? For an invention to be allowed, it must be novel, inventive and useful. Now, I'm not very good with colours, and I know you've all just had lunch, but that's the one thing in red that I want everyone to take notice of. It has to be novel, not previously publicly available. That's really important. That's what I said before about the secrets, hence the colours and the flamboyance. It's all about not publicly available with a secret. You can go back to sleep now if you've had a good lunch. But you be the judge. Now I'm going to get you to answer some questions for me. Having been transformed from your ordinary work, we will take you on a ride. Don't worry, it'll be safe. You can tell me. Number 1, should this be patentable? This is a terrific invention. This is a pedal-operated mower bike. It is a tricycle with a mower assembly, an array of blades and a drive chain. Don't you think that's great? You can set the kids to mow the lawn. Do you think that should be patentable? Yeah, give it a nod. It's a good one. Yeah? Right? This is your easy way in. Yeah, that's right. If you're paying attention, you can look up in the top right-hand corner there and see it was patented. As a granted patent there in 1984. Will be expired now. Okay, so that was the easy one. Now for the hard stuff. Number 2, if you knew this is the background information. That thiopurine drugs can be used for treatment of autoimmune disease like Crohn's and ulcerative colitis. If you knew that if the dose is too high, you get side effects, and the dose is too low, you get lower efficacy, and you knew that people vary in their metabolism, so sometimes it's a bit hard to predict what the right dose is. So would this be patentable? A method of optimising therapeutic efficiency. Step 1, administer the drug to the patient. Step 2, determine the circulating drug levels in the patient, and then if the levels are below 230, increase the dose. If the levels are above 400, then that should say decrease the dose. Right, typo in there. So there you have it, a method of optimising therapeutic efficiency. Do you think that should be patentable?
No.
Got a very clear no there. So the US Supreme Court said of those facts, not patentable. It's an attempt to monopolise the correlation found in the law of nature. So there's a correlation between the circulating drug in a patient and what the measurement was. So the impact of that on patenting of diagnostic tests has been quite significant around the world of intellectual property. So when we're looking for new ways of diagnosing diseases and we want to protect those discoveries, we need more than an observation of nature. So we need more than just saying, I've seen what's happening there. We need to do something about that observation of nature and take some action. Okay, number 3, if you knew this, that omeprazole, which is a drug, can inhibit gastric acid secretion, is degraded by acidic conditions and is unstable. And if you also knew that enteric coatings are available, would this be patentable? This is omeprazole with the green layer there, an alkaline subcoating layer, and an outer enteric coating, the red one. Should that be patentable?
Yes.
Yes, getting some good feedback there. All right, we think yes here for the online audience, and that was true. Yeah, the Australian High Court came to the idea that was a patentable invention. It was patentable in the combination of integers. Even though some of the parts were already known and there were routine steps that were obvious to try, they did not lead directly to the solution. So that was a patentable invention. That was the High Court's decision. Okay, number 4. If you knew this, that leflunomide was that compound there, and could be used for the treatment of rheumatic complaints or multiple sclerosis, then would this be patentable? A method of treating a skin disorder, wherein the skin disorder is psoriasis. And the method comprises administering the composition to the patient. So think about this. We've got a patent system that is designed to encourage innovation, so that people will innovate, they will look into new areas, and that other organisations will fund that work so they can protect it. If they can't protect it, then they might not fund it. And they won't be able to get their money back, they won't invest. So here we have a method of treating someone using a drug that is already available, but it's not known to be available for this. Any ideas? Any thoughts? Do you think this should be a patentable thing?
Yes.
So we're encouraging exploration into new areas. So the Australian High Court agrees with you that this is a patentable method. A method of medical treatment in Australia is a patentable invention. It's not the case all around the world, but in Australia and the US, a method of medical treatment. So think about who's going to do that. Who's going to develop such an invention, and who's going to patent it? Who's going to enforce it? And who are they going to enforce it on? They're going to enforce it, well, we have pharmaceutical companies that are going to label a product as suitable for a new disease. That's who it can be enforced upon. but who else? What we don't want to be doing is enforcing patents on clinicians. Okay, number 5. Should this be patentable? Straight into this one. An isolated nucleic acid. So a sequence coding for a mutant or a polymorphic polypeptide. When the mutation is associated with susceptibility to breast or ovarian cancer. So we've got a genetic sequence with a mutation in it that is associated with cancer. Is that the sort of thing we want to encourage, protect? We want to look for those sorts of things? Should that be patentable? Think about it's the sequence itself. That's what the claim says. Anyone in support? No? All right. So the High Court of Australia said not patentable. The substance of a claimed invention is information that's embodied in arrangement of nucleotides. So there's a chemical formula there, but it's an arrangement of information. It's not made by a human. It is discerned by the human. It is discovered. It's not a tangible product, and it's not patentable in Australia. So for the molecular biologists in the audience, let me have a quick segue over to the Australian Patent Office where they dissect that and tell you a bit more about, so what is patentable and what isn't patentable in the biotechnology area. So here's a summary of their list, and if you care to go to that link down the bottom of the page, you'll find a lot more detail about what they think is patentable and what isn't patentable. So anything that's isolated, so isolated bacteria and protozoa, all those things in the list there, and genetic vectors and expression systems, they're all patentable. And modifications of any of those things, so genotypic and phenotypic variations of living organisms, isolated peptides and proteins, and nucleic acids is sequences if the sequence does not exist in nature. So in the previous example, that mutation was a natural mutation that existed. That's not patentable, but patentable sequences can be, patents can be made for sequences if the sequence doesn't exist in nature. And we can also get patents for methods of transforming using the genes, that sort of thing. Patents are not available for human beings and the biological processes for their generation. So cloning and things like that and cell culture can sometimes fall foul of that law. Nucleic acid sequences that exist in natural genomes and any microorganisms in their natural environment. So we can't just try and patent something that exists out in nature. Last one, should this be patentable? A method of altering expression of a gene by introducing our CRISPR system. Everyone heard about CRISPR in the news? Yes, CRISPR's big news. You don't need to know what it does or how it works, but it can alter genes. It can alter gene expression. And in this particular patent application, there was lots of claims. The 31st claim there was to the cell that comprised the altered gene expression of the method. So that's limited to eukaryotic cells, a method of altering expression in a eukaryotic cell. So that's a fair bit, isn't it? Eukaryotic cells. Should that be patentable? So there is an Australian patent. That's it. That's what it looks like. Granted to MIT and the Broad Institute for CRISPR-Cas systems and the methods of altering gene expression. So that came into force in 2013 and will last for 20 years. So that's that, which moves me nicely on to, can you be sued for doing research? Now, does anybody think there's gene expression work with CRISPR going on in this building or around the Parkville precinct?
Yes.
You better believe it. So the Patent Act of Australia says that the following activities are exempt from patent infringement: determining the properties of invention, determining the scope of an invention, improving an invention, or determining the validity of an invention. So that means that if you're doing one of those things, then you can't be sued. There's an exemption from patent infringement. I'll summarise that on the next slide to say that working on an invention is okay, working with an invention is not okay. So if you're working on the CRISPR system and you're trying to figure out how it works, how to make it better, whether or not it's a valid patent, then you fall within that infringement, fall outside the infringement in the exemption. If you're working with an invention, then that's not okay. That's the whole idea of patents, is that they protect the area that falls within the patent claims. So that's where a lawsuit can ensue. The use of patented research tools. So if there is a research tool like CRISPR that's patented, then that doesn't get you out of an exemption, doesn't get you out of patent infringement, just because you're using it in research. If you're doing research with an invention, then you can potentially come within that problem zone. Okay, researchers in the audience? Not too many. No? Where are all our researchers? Okay. My 6 top tips for publishing and commercialisation. Hopefully we've got some people online. So, number 1, know the difference between invention and discovery. I talked earlier about observations of nature. What is the difference between an invention and a discovery? Discovery is finding something that already exists, and that's a lot of what research is. Invention is creating something new that didn't previously exist. So that's doing something about it. Discovery is finding something new. Invention is doing something, taking some action on the basis of what you discover. And that's where we look for patents. Using something that already exists in nature is a discovery, not likely to be patentable. We need to do more than just observe nature. Tip number 2, understand enabling disclosure. So if we have a secret, new data, it's only just come out. We might not plan to keep it secret, but we might. If that new data is spoken about publicly in a forum like this or anywhere that's uncontrolled, then how much can we say without getting in trouble? Well, in patent law, we have this concept of enabling disclosure. So the information that's conveyed will become a barrier to patenting when we provide sufficient disclosure to enable the skilled person to put that invention into practice. So we've got to give them some detail enough to enable them to carry out the invention. That, what we say, becomes prior art and enables that reader to understand and practically imply without doing any further invention, then they can carry out the experiments can carry out the invention. Now that's what the amount of information is. So an enabling disclosure is just that. Tip number 3, get the patent timing right. What did I say was the key ingredient for a patent? A secret. Someone's paying attention. Excellent. Anyone else remember this? I did that for a reason. It's all about timing. So, if we publish our work and then we go along to the patent office and we file a provisional patent application, we go through the long and difficult process through a PCT patent. we get through to patent examination, then the patent examiner will say no. Patent examiner will say no because on the day that we filed our provisional patent application, we didn't have a secret. It was already been published. So we can't do that deal. I spoke earlier about the deal between the inventor and the government. There is no deal to be done. You don't have a secret that you can exchange with the government. But if that story was just a little bit different, if we had filed a provisional patent before the publication, as little as one day before the publication, and we do that all the time, then when we go through regardless of what happens later, we go through the subsequent patent steps, then the patent examiner will say, yeah, that's okay on that criteria, because on the day we filed the patent application, it was still a secret. So we still had that secret. We've still got a patent and a publication, so we've got both. They can happen both together. We routinely file patents the day before the information's published. That's what we do. So the information still goes out through both channels. So we get the patent and we get the copyrighted publication as well. Tip number 4, know what is publicly available. So sometimes it can be difficult to tell what is publicly available. So let me give you a quiz. We'll see if people in the audience can tell me this. If an article is submitted for publication, what do you think? Is that publicly available? It's just submitted. No. Just when it's submitted. No. Shake your heads. Shake your heads. Yeah? That's a no. What about when it's published? Yes. Uploaded to Facebook. Publicly available? Yes. Presented at a conference?
Yes.
Discussed with someone else within your organisation, but in a different department or a faculty. Someone in medicine talking to someone in engineering. Publicly available? No, it's not. The law would consider that to be still within the same organisation, especially when the organisation is owning the intellectual property, then they would consider it to be still contained. It's reasonable if you're wanting to keep something confidential, though, to tell the people you're talking to that you want to keep it under wraps. What about a grant application? Just applying for a grant. Is that publicly available? You've written this enormous amount of application together. Send it in. No, the grant reviewers are under an obligation to keep those things quiet. That's all right. But then when the grants are awarded, the announcements go online. So that's publicly available, right? So if you're writing a grant application, have a think about what you put in there that might be going in the online part. So sometimes we have grant applications that we put in before the work's done that come back to bite us later when we're trying to patent something and we see the titles and the bits that's gone online. What about a thesis examination? So where someone's written their PhD thesis, their honours thesis, and we send it off to someone in another university, another place on the other side of the planet for them to have a look at. Do you think that's publicly available? Ooh, a few nods. So, but think about it. We've sent it outside the organisation. We're going to ask that person to keep it confidential or not. Publicly available is publicly available. We've got to ask them, perhaps under a confidentiality agreement, to keep it confidential. Otherwise, we haven't told them what we want them to do. We've told them to examine the thesis, but they might think they might do something else with it. Then, once this thesis is successful and we submit it to the library or online, publicly available?
Yes.
Right, we're all agreed on that one. Yep, we're going to put it in the library. That's the whole point, right? That's the whole point of all of this work's been done. We want to make it available. So it goes in the library, on the shelf, or online. Unless There's a little box that people can tick to say keep it embargoed for 2 years or 5 years or whatever it is, which can enable that to be patented during that time. Tip number 5. Understand when you're an inventor. So an inventor is responsible for the inventive concept. So that's the mental part of the invention, different from its reduction to the practice, the physical part. That's who is an inventor. They have that knowledge, they've come up with the concept, and they can prove it. Let me give you an example. So here's a device. Look at this, isn't this cool? So I'll have to explain it to you. If you want to dig a telegraph pole out of the ground, how are you going to do that? These guys, Eric, Ron, Gavin, came up with a circular drill thing that they could bolt around a telegraph pole and it would dig down circular fashion, right? So they could pull out the pole when it had passed its useful life. Eric dreamed up the idea, but he didn't have the skills or money to get it to work. Ron collaborated. If you read this, he even sold his car to finance it, but he didn't have the idea to start with. Gavin was the guy that made it. He actually physically made the thing, and he encountered some considerable difficulty in getting it to work, but he didn't change the original conception. The Australian Patent Office said that Eric, the first name there, he was the inventor and the only inventor. It didn't matter that Ron had sold his car to fund the invention. And it didn't matter that all the work that Gavin had done was physical work and just reducing it to practice. So that's a clear indication of what we mean by an inventor. So I said an inventor was not only responsible for the concept, but also able to prove it, which leads me to my last tip, which is keeping good records. Good records are good for lots of reasons, for repeating and validating experiments, for writing up materials for publication, for compliance with lots of things, but also for establishing inventorship and establishing the date of invention. So that's very important to figure out who's an inventor, who owns the invention, where were they working at the time, was it on the weekend, or was it their day job? Okay, last one. How can a patent monopoly be extended? So in research that I conducted, I was in a team conducting this at the law school, Melbourne University. We looked at all the drugs that cost the Australian government so much money. So evergreening is the use or possibly the abuse of the patent system to go beyond the standard 20 years of patent life. That's an assertion. So we looked at the top 25 drugs that cost the Australian taxpayer billions and billions. It was about $8 billion when I did this work. It's probably a lot more. The top 25 count for half of that. It's a massive amount of money. So we thought it worth shining the light on where were the patents in there. We looked up the costliest drugs and the patents associated with them. We started with more than 5,000 patents, and I looked through them. These are the drugs that we ended up in our study list, some household names that the Australian government spends a lot of money on. We found many of the patents applications were never granted. They didn't survive the patent process. They didn't survive examination. That knocked out about 2/3 of them. Then we discovered, if you look at this on a whole, there was about 49 patent applications that related to each of these drugs. 49 patents. That was after we'd excluded a bunch that they just mentioned the drug in passing. That's a lot of patents. Then what we found was that the the patents that were in force and had effect really fell into 7 different categories. If you read this list from the bottom, there was the original patent, the original active pharmaceutical ingredient. That was the first category. Then there was the category of intermediates and different forms, so isomers and different chemical constructs. Then there was combinations, so a combination of 2 drugs together that was somehow better than just giving them side by side, those combination patents. Then there's drug delivery mechanisms, so skin patches, any sort of drug delivery, any sort of slow release formulation, things like that. Then there's the 5th category was processes for making them. So processes, industrial processes for making the drug, for getting it into capsules of a special size or a special way, lots of those things. Then there was methods of treatment in Australia, which is patentable subject matter, as I said before. So a method of treatment using the same classes it was originally designed for, and methods of treatment for a different class of, so a different indication, if you like. So different way of, different method of treating. So those were the 7 categories. The really surprising thing though is, if you look at the grey bars there, that, let me go on to the next page and I'll come back. Those 7 categories, 3/4 of all the patents were not owned by the original drug maker. And the generic companies were really patenting heavily in delivery mechanisms, formulations and methods of treatment. So I'll go back to that previous slide. Have a look at those grey bars. So the black part is the original owner. The intermediate grey is another originator. So another pharmaceutical company that also makes new drugs. And the light grey is a generics company that don't make new drugs by themselves, but we know them as the ones that produce the drugs when they're off patent. They are all heavily patenting in those areas, just as much and more than the original creators. So that was what I thought was the most surprising finding there. Okay, and that's it from me. I'll stop there, so open up for questions.
Thank you, Lachlan. That was an excellent discussion of intellectual property. I hope you've all enjoyed it very much. I found it very informative. I might start then, if I just might, on your last slide there. Do you mean to say then that the people with generic drugs also hold patents in some way for that drug, or do you mean that they've got into the market and they just happen to be the manufacturers of the generic drugs that were once subject to a patent?
So they are in the market selling the drug, but they are patenting new delivery mechanisms
in order to protect their investment.
In order to protect their investment in that, yes.
Isn't that interesting? I had no idea. I don't know if anyone else knew that. Question here down the front.
Actually, my question was the same as that one, but could you give us an example of where that's going on? And I mean, so does that go for both the light grey part of the bar and the dark grey? Because I mean, I know there's a lot of discussion about research into repurposing of drugs that are already patented, and you know that sort of research is possibly being discouraged because it lacks the ability to commercialise. But this looks like the pharma companies are trying to find ways around that, like if you're moving from one manufacturer to another.
So I lost track of what your question was and all that.
Well, could you give us an example of what's of a drug where these kind of processes have gone on with the repatenting of it, and also like the context around how that fits in the context of repurposing drugs that are already patented or out of patent, I guess.
So the repurposing is definitely in that second from the top category. That's methods of treatment for a different ATC class. So that's a different indication to what was originally patented and what was originally known. So it's a different indication. So that's certainly, there's a lot of that going on there you can see with the non-originators. As to specific examples, I don't think I could give you a particular one, but certainly there in the delivery mechanisms and the formulations. So someone can have a patent for I'll keep saying the slow release patch. So they've got the drug that in the slow release patch that can, a skin patch rather, that can be applied to a patient. That doesn't stop anybody else doing something different with the drug. There's lots of different ways that can be done, but it protects their investment in that area.
How long does a patent pending last, and can you extend it and protect your invention, ad infinitum? So
it lasts for 20 years. And so to answer that question about patent evergreening, you actually can't extend it, with the exception of there is a bit of extra time for new pharmaceuticals, that bottom category. You can get a little bit of extra time if you have delays in regulatory approval. The rest of them, they last for 20 years and they stop. The evergreening is by making something somehow better. So by that one of those early examples I said, where there was a capsule, so the original drug patent expired, but then the method of making it survive through into the intestines, past the stomach, that was the patentable bit. That didn't stop someone else producing the original drug. It just protected that layered effect on the capsule.
And just another one, how rigorous is a trademark? For instance, with the trademark just behind you there,
yes.
If I change the colour pattern, would I be allowed to do that?
So there is a...
It's not my trademark, so I'm not saying anything.
There is a concept in trademark law that is got to do with identity and similarity. So they are held up side by side to tell whether there would be confusion in the marketplace. So if you can hold two things up together and you're confused as to is this the same place, then that's probably a good test.
You might remember there've been lots of cases, but the one that stands out for me is Cadbury and the colour purple. Do you remember? Big federal court fight over that too. So any other questions? Because I have one more, if you don't mind, Lachlan, and that was about your slide with Eric, who had the idea. Do you remember the case? And the other two who had put their time and money into bringing that to life were held, I believe, not to have had any inventorship. Is that correct? So my question is, if those three, Eric, Ron and Gavin, had been employees of Melbourne University, would you share 40% with only Eric, or would you include Ron and Gavin? So hypothetical.
Good question. The university has the facility to enable all of those people to get some of the money.
Yes.
But it would depend on Eric.
It's discretionary.
It would
depend on Eric.
It would be Eric, at Eric's discretion, yes,
Right.
to share that money.
Oh, there you are. Interesting. For those of you who are from Peter Mac, we also have an intellectual property policy that shares any revenue as employer that we might derive from someone's invention. So that's similar, but again, it's at the discretion of our board. So it's not set in concrete, but there's a suggestion along those lines. Time for one last question.
I'd just like to revisit a comment you made earlier on, Lachlan, which was concerning the, in the case of university or other employees, that the intellectual property for their publications was not owned by the organisation. Did I hear that sort of correctly? Were you speaking specifically about journal publications or all sorts?
So the journal generally owns the copyright in the final print, yes.
So in this day of open access material, then how does that stand up?
Yeah, I can answer that.
Yeah.
You have to ask permission of the journal if you want to reproduce it usually.
Yes, but in these times when we pay a lump of money to a publisher and they say, right, the Creative Commons licence is yours, does that mean that we then, as the writers of the material, do retain the ultimate ownership of that material? I just want to be sure that we're not getting into triple loops here.
On each, in my own experiences, I think it depends on each agreement. Some publishers will require you to assign copyright.
No, most certainly.
And
yes.
others may say it remains with you, but I think it's always better, my own advice is it's always better to check with the editor of the journal before one reproduces.
Yes, thank you.
All right. Well, thank you, everybody, very much for attending. Just if you could join with me in thanking Dr. Wilson so much for his entertaining speech. Thank you. Thank you, Lachlan.
Okay.
Well done. Thank you very much.
Thanks very much.